discovery.
All right. Anything else, Mr. Armstrong?
No, I thought it was agreement that if there was good cause for an extra motion.
Yeah, I would concur that that the court will entertain additional motions. You can put that in your order. That I will entertain additional motions for good cause shown. All right.
Well, yes, Your Honor.
Okay. All right.
Moving to Mr. Long's motion number 11.
All right.
It is our motion to require investigative agencies to preserve notes on all interviews and investigative actions. On page 3 of the motion, we quote United States versus Palula 105 F3rd 117. And basically there it talks about where a conviction was reversed because the state or the government, U.S. government in that position, in that point, failed to disclose the raw notes of the FBI and IRS agents. Under State v. Blackwell, 245 Georgia Appellate, 135, 137, 138, 2000 case, the state has a constitutional obligation to preserve evidence that might be expected to play a significant role in Mr. Long's defense. So in terms of preserving the notes on the interviews, I mean, we go back and forth, I'm sure, not only in death cases, probably in a whole lot of other cases, that issue about investigators' notes, what should be preserved. And again, as the state has agreed, this is different, death is different. And so that's another reason, because sometimes as we go along in discovery, we figure out, oh, maybe we don't need the notes. We got a summary here that covers everything. And then we'll see a summary that's like just not quite right. And we need some more reinforcement or put it under a microscope, and we need the notes. So that's why we're asking for that.
All right. Sure.
The state is asking the court to deny this motion because Georgia law is clear that there's no constitutional or statutory right to rough notes in this manner. In particular, in this case, it's much less important given you have a recording of the interview itself. So the officer's notes from an interview such as that are of much less value, even if they were something that would be required to be turned over, but they are not under Georgia law. And again, death is different. That is the care to be given to the standards. It does not change the standards.
Just to respond to the part about it being, electronic videotaped or audio tape. I mean, most of the statements that defendants make nowadays are. I think good investigation causes that. But there are many times, and I think the state knows this and the court has seen enough cases, where notes that were taken did not include what was on that particular video, what was on that particular audio. And so I think we have to think about that as we move forward, and that's another reason to preserve the notes.
I'll deny the motion, but I'll reserve any other further issues for good cause. I mean, if you have experts, and certainly they refer to notes or rough notes under 704 or any of those particular subsections, or refer to notes in order to aid their testimony prior to trial, then certainly those notes would be required to be turned over to you, or other circumstances. So I'm going to deny the blanket motion, but there are circumstances that the court could see where you would be entitled to, or may be entitled to notes. Okay?
Yes, sir.
All right.
Motion number 12 is Mr. Long's motion to compel disclosure of confidential informants. The state's response is that the state asserts that there are no confidential informants. So I'll let the state respond. If there are none, then this motion is not needed at this time.
Not ripe.
Right.
Okay. All right.
But
okay.
That's what the state has asserted in their response.
All right.
I've just confirmed that since the filing of this document, we have not gotten any new confidential informants, so the number is still 0.
All right. To that extent, Mr. Lamar, you can prepare an order to that extent that the state is proffered in open court that there are no confidential informants to be utilized in this particular case, okay?
Yes, Your Honor. Let
All
me
right.
just write that down.
All right.
Thank you.
Correct.
Your Honor, Mr. Long's motion number 13 is our motion for an order to preserve all evidence and to preclude any additional state testing of evidence that would alter, reduce, or destroy evidence without notice to the defense and prior court approval. Again, in this particular case and in most cases, there is evidence that the state has in its possession, and I'm not sure about how much biological evidence there is, but this motion is designed to cover all of that. And what we're asking is that on page 14, we do a specific list, but that list is not all-inclusive in the things that we're asking. I know the state objects to this motion. The reasoning behind this motion is that it has been found in the last, I would say maybe the last 20 to 30 years, especially concerning biological evidence, concerning audio tapes, videotapes, that if they were preserved and when they were preserved, people were exonerated. And if not exonerated, brought in, evidence that was brought in to get a new case, a new case remanded or to get a new trial. I think as our technology, and that goes to electronic evidence now, because people delete stuff and they think it's gone, but then when it's recovered, we find something else out. So in terms of preserving evidence, in terms of any kind of testing or using it, thumb drives, all of that, we think that the state should be under a mandate to preserve everything. If there's a chance of testing it or looking at it, that's going to destroy or use some of it up, as can be done, we think the state should give the court notice and the defense notice.
All right. Sir.
Yes, Your Honor. So the state preliminarily announces that we have no intention of destroying any evidence of evidentiary value or anything that would be something that we would be required to turn over under the United States Constitution. However, the motion is made is not something for which we can provide agreement because of how it is written and what it requests. In my response, I divided it into 4 different sections. For 1, we take no position. For 1, we completely agree. And then for 2, we think the court should deny the request. The first request, the one that we do not take any position on, is their request in the motion for the court to make the clerk of court the custodian of evidence. The court could theoretically do that, but that would be a single case for which the clerk would be made the custodian of evidence. And if the court were to consider granting that request, we would suggest the court communicate with the clerk of court because that would affect them, and they might be unable to do that for a single case.
Are you talking about like evidence that's admitted during trial?
Correct.
Usually my court reporter is the custodian of that particular
Correct, but eventually
evidence.
they will be turned over to, under a previous chief judge's ruling, I believe in 2017, we were designated the custodians of evidence beyond the point in time in which they file things. And so things are often turned over to us that are not retained by the court reporter or for older cases. And we have our evidence unit that becomes the custodians of evidence. And that's what they are asking the court to change in this particular case, that rather than the district attorney's office at that point becoming the custodians of evidence for the clerk of court to be it. But we didn't request that in 2017. That was something that was just directed. But this would be the only case for which that would apply if you were to grant their request. We take no position on that because we have no interest in becoming the custodians of evidence. We do that because we're required to and because somebody has to. The second situation is about biological material. We absolutely agree, especially in a death penalty case, that biological material that identifies the defendant as the perpetrator of an offense is something that must be maintained. And in the death penalty case, it's something that must be maintained up until the point, I believe, of execution, if there is an execution. We don't disagree with that. However, in this case, the defendant is identified by his admission and surveillance video showing him very clearly to do that. He's not being identified by biological evidence. I've confirmed with Mr. Abadi that since the filing of this response in which we identified that there is no known biological evidence that identifies him as the perpetrator, we have not received additional information of that, so that we don't have such evidence. But that was the part to which we agreed with the motion as written. The other portions are the defense broadens their request and basically asks for everything ever. And so that would cover things such as the last motion that the court denied with reservation. And so I would just point out that Arizona versus Youngblood points out that there's no undifferentiated and absolute duty to retain and preserve all material that might be conceivable evidentiary significance in a particular prosecution. And they're going beyond that and talking about all evidence, all matters entirely. And so we object to the motion is made for that. And then finally, there is a section where the defense is asking for the state not to perform any tests without preclearance from the defense. That is mainly something that in other cases is requested for biological issues. The law already requires that we don't test things that would destroy all available evidence. But again, there's no DNA evidence in this particular case, so the court does not need to grant that for DNA evidence. The state would submit that if there are additional testing, say of a firearm, that is not something for which the defense has a right for preclearance under any law that I'm aware. And so with that announcement, the state does not take a position on the issue of custodian of evidence. We agree that any biological evidence must be preserved, but there is none that we are aware of, and we're asking the court to deny the remainder of the motion is made.
All right.
Yeah, just responding in terms of the first issue, in terms of the clerk of court or where the evidence should be held. It's been our experience in death penalty cases, even in terms of certification, interim review, that usually the clerk has everything and sends it up to the Supreme Court. And then post-conviction, of course, same thing. So that in death penalty cases, there's usually, especially interim, there's an immediate review if it's granted, if the court certifies it. And I will tell you from experience, one time it was crazy. I think it might have been in the Carmen case where getting everything together from the different entities was just really, really hard. And I think the state may remember that. And I think that's one reason that we asked for it to go to the clerk of court. Not putting any aspersions on the DA's office. Or like you said, your court reporter will have it, whether it's interim review or post-conviction review, getting that full record together to go up to the Georgia Supreme Court is so important. And having to go get it from the DA's office to make sure everything is together to send it up in terms of a record sometimes can be somewhat burdensome. So there is a particular practical aspect to this.
How come I couldn't just, during the trial of the matter, make my court reporter the custodian? Because she keeps everything anyways, because it's because we have to keep track of those things that may be in trial or not. After such trial, I could make the clerk a custodian. Would that work?
Yes, sir.
All right, I'll do that then.
Your Honor, may I just add some additional information?
Sure.
Because that's not the custodian of evidence issue so much. That's about what has been filed with the clerk. Nobody is giving anything to the Supreme Court other than what's been filed to the clerk when we do interim review or review at the end of the case. And so the one issue that we have had in other courtrooms is that when at the end of a case the state accepts evidence as the evidence custodian, media exhibits will not have been copied and turned over as a separate exhibits transcript to the clerk. That's been the only issue that I'm aware of as far as having to get things back from the state as evidence custodian, because the only issue would be if before the end of the trial just require that before any evidence is turned over to the state as evidence custodian, that all media exhibits be copied and filed with the clerk. And that would obviate this issue, because that's not an issue with the evidence custodian. That's the issue of what has been filed to the clerk, is what Mr. Lamar has identified.
Part of that is you all's responsibility as advocates, but a part of it belongs to the court reporter, because those particular types of exhibits have to be copied in such a way so that they can be preserved for the record and go up with the record. I having done this a while, I understand that. Most court reporters and advocates understand that. So I think we're on the same sheet of music, but just to make things easier for this particular trial, I'll go ahead and just during the trial of the matter, and of course Ms. Weaver will consult with all of you to make sure, because she has to make sure the record is clear to begin with, to make sure that all exhibits are included as part of the record. And then once the trial is complete, then the clerk can become the custodian at that point in time for each or any appellate purposes, should there be required. So, Mr. Lamar, if you'll prepare an order for my signature for that. Okay, so that's the custodian issue. Let me roll up a couple of things.
Your Honor, I do apologize. Just to go back, because if the court orders that the clerk is the custodian of evidence,
But this case,
that would include physical evidence like firearms, things of that nature. That's what custodian of evidence typically refers to. And so the clerk doesn't have anything at this point in time to take the physical evidence. And so the clerk would simply be the custodian of evidence that has been filed, copies of which have been filed. But I just wanted to say before the order is signed that the custodian of evidence typically refers to physical objects. So if we brought in a victim's clothing or something else, those physical objects go to the custodian of evidence, and the clerk's office does not currently have the capacity to take those physical objects. And that was just simply my concern of saying that the clerk will be the custodian of evidence, because they're simply the repository of filed materials.
yeah, Mr. Lamar, you'll make Ms. Alexander very annoyed, because she doesn't have anything for us to store it, and at this point in time, I'm not going to put that responsibility upon her. So I'll default to you've asked for it, but at this point in time, I don't have a mechanism.
Right, and I also could say, if we're in a hearing, and let's just say there is some evidence that is tendered, some physical evidence, I think, let's just say it's some clothing, or pictures, or something like that of the crime scene, maybe in terms of our, similar transaction evidence hearing. I think those type of things, depending on what it is, kind of like what Mr. Armstrong said, I think we can figure it out. The other thing I wanted to ask the court about is the court fine with me putting also not only evidence that would go up post-conviction, but also interim review, in terms of not evidence, but the court file? Because I said that it also, if the court certifies interim review, that everything has to go up then too.
Well, the same procedure would be appropriate.
Okay.
The clerk assembles the record. I should say Ms. Weaver assembles the record. The clerk transmits the record. So you're still going to have any physical evidence that may be will remain in the repository of the district attorney for the time being. So yes, because they are the custodian for physical evidence, as designated by my predecessor in 2017, Judge Brasher. Okay.
And just checking again, I'll also be putting interim and post-conviction review. Sure. Yes. Thank you.
All right. Let me go on to the biologic and testing procedures. If you would put a statement in the order that the state has represented that there are no biological materials to be tested.
Yes, sir.
Thus, the court would not have to determine any test to be predetermined at this point.
Yes.
And then the last thing is a preservation order. I'll order that any items that may be subject to testing, not be destroyed or altered in any way.
Yes, Your Honor.
Okay?
Very well. All right. So moving on, Your Honor, to our motion number 14.
14.
Yes, sir. Motion number 14 is Mr. Long's motion for disclosure of similars or extrinsic act evidence and for a pretrial hearing to determine the admissibility of any acts alleged by the state to be similar transactions. And the state's response basically is no objection.
So the state's not going to present any similar transaction or string?
They are. They are. And
Well, I think we're going to have to schedule that for a hearing. Is that the one we're going to hear on the 20th of May?
Those were evidentiary hearings, right?
no, yeah, that's not one of them.
Okay, all right, so has the state filed a motion for similar transactions or?
So the response is a little bit more detailed than that. The defense has asked for the court to essentially issue an order ordering the state to comply with discovery. The state submits the court should not restate the law, and that the state submits the court should simply issue its expectation that the parties follow the law. That's the general part of it. Regarding procedure, the defense asked the court to follow an obsolete procedure on other acts evidence that was abrogated after the new evidentiary rules when the Superior Court judges removed the rule that they were referring to from the Uniform Superior Court rules. Next, the defense has asked about other acts evidence under 404B, cross-examination, and impeachment under 609. The state fully intends to comply with those laws, but we don't think that the court should have to issue an order about that. Now, part of our response is that we have notified the defense in bold and underscoring that we intend to present any and all evidence that is in discovery that talks about other events from the day, including in Cherokee County, including afterwards, including any relationship that this defendant has with any of his victims and the locations themselves. Those are intrinsic evidence, so that's something that we don't have to provide them notice for, but we wanted to make sure that there was no question in the record that we are intending to present that. Next, we do not at this point in time have 404B evidence to present. However, we are not saying that we never will. We will provide notice as appropriate for Rule 404B evidence if we obtain such. However, there's also one additional matter that I wanted to have, which is that we typically do not need any kind of pre-clearance for admitting negative other act evidence in the sentencing phase, because at that point they're judging the individual and not the guilt and innocence for the specific crime. And so I included the law in there, and I also provided them with the notice that we intend to present anything that we have presented in discovery that is negative about the defendant, that sheds light on his character and on the appropriate punishment that the defense must have. But we do not object to having a hearing at which if we intend to submit evidence under 404A or Rule 609 that has to deal with a prior conviction. If we find such evidence for 404B or prior conviction under 609, we have no objection to having a hearing outside of the presence of the jury that determines the admissibility of that evidence.
All right.
Response, Your Honor.
Yes, sir.
I think this, a lot of these motions kind of bleed over into other motions, and I think what Mr. Armstrong has stated actually goes to kind of our reserving the right to file additional motions, because the state says it has an absolute right to bring, especially penalty phase evidence. And we're saying, okay, but at the same time, we have a right to challenge that. We have a right to challenge that in the first phase and the second phase, which then if you don't say what you're going to present, then it makes us have to file 25, 30 motions worrying about what we think you might present. So I think that's one reason for the notice. That's one reason I think that there has to be robust discussion about character evidence, about similar acts evidence. So the state has said that they don't mind, they're not objecting to having hearings on that. And we would also add, Your Honor, that we would probably be seeking hearings on, if they don't say it explicitly, in this particular case, there are things that rumors or other things that could come up in terms of penalty phase that we believe we have a right to keep out, but the court would have to make that decision.
Okay,
All right, may I add a note?
you may.
Back when we filed this in July of 2022, we let them know that any and all evidence that we've turned over in discovery that is negative about this defendant and his character is something that we intend to present. So we're not identifying specifically, we're going to do this specific fact and this specific fact. We intend to present all of it. And so if there's an objection that is based on something lawful, they have had that notice for a year and a half. I just wanted to make that notation.
All right. Here's what I'll do. And it pertains to defense motion number 14. I'm just going to require the parties to file the applicable notices as appropriate per statute, and I'll handle it that way. Okay?
Yes, Your Honor.
All right. What's number 15, sir?
Your Honor, our motion number 15 is Mr. Long's motion for release of records of the Board of Pardons and Parole. I believe the court is aware that Mr. Long has been adjudicated in Cherokee County on similar charges. So he is actually under, the auspices of the Department of Corrections at this point. And those records, in terms of the Board of Pardons and Parole, at whatever point that we possibly have a trial, especially in terms of mitigation, penalty phase, UAP directs us to investigate any and everything. And one of those things would be his records in terms of his being under the records of the Board of Pardons and Parole. So we're asking for that. We're asking for the court to issue an order that we can get those records in order to defend Mr. Long zealously at any penalty phase hearing.
All right, sir?
Yes, Your Honor. The state is going to ask the court to deny this motion. First of all, I cannot fathom what evidence about this particular case would exist in the Board of Pardon and Parole's records. They typically consider their records to be state secrets, and they are separate state agencies. So the state submits that if they wanted to seek their records, that the Board of Pardons and Parole should probably have been a part of this hearing. I will let the court know that in a non-death penalty case where somebody is reviewing the case for a direct review of a murder conviction, the defense has subpoenaed from the Board of Pardons and Paroles their records involving the case, which that involves an individual who's been there for years in their custody as opposed to local jail custody. And the Board of Pardons and Paroles responded with a pretty robust document that says the statute very clearly says that these are not things that can be turned over. I don't have that information in front of me right now because that is somewhere in case management, which I do not have access to at this moment given the outage. However, that is something that if the court considers, that is something that the Board of Pardon and Parole should be involved in, because it seems that there is a lot of specific laws that prohibit them turning over these documents or that prohibit individuals from giving them. But also, if the defense does receive anything from the Board of Pardons and Paroles, the state would request the same, but we don't expect that to occur.
I'm sorry. And, Your Honor, I just wanted to, I neglected to mention that another procedure that we are amenable to is that the court review those records in camera and see if the court, we respect the court's ruling on that. So
That's if they'll turn over the records to me. I mean, I agree with Mr. Armstrong that those records are subject to a third party and they got lawyers. And you're going to need to probably work that particular process. If you need my assistance, then certainly you can file a motion and a subpoena.
very well.
And we'll take it from there. I assume if we get to the penalty phase or anything like that, that you would be anything that I guess you're trying to seek the records to show what activities or if anything are applicable.
Yes.
For his custodial stay. Is that right?
Yes, sir.
Okay. Well, you're going to need to probably file an appropriate motion and see if the pardons and paroles will let you have that particular issue, and we'll cross that bridge when we come to it. So I'll deny the motion, at least in terms of the state, but and ask you to file a motion with the pardons and parole.
Of course, no, just one moment, yeah.
Mr. Lamar, I tell you what, I'll let you file the motion. I mean, I'll grant the motion, but you need to file the appropriate notice and subpoena with the Board of Pardons and Paroles, okay? Should you decide you wish to pursue that.
Right. Ms. Bell wanted to address an issue about that, and thank you.
May I?
Yes.
Just to let Your Honor know, so there is actually an exception for capital cases.
I thought so.
And so that's why this is actually the motion that we need, and it requests that the record be turned over to the court to review it. The order that we get from this, they will take that order, they will send the records to Your Honor for review before they come to us. This is a standard procedure because they have that exception.
All right.
built in.
If you'll prepare a suitable order from me, I'll go ahead and do that, okay?
Yes, Your Honor.
All right,
Yes.
then. Okay, that's fine. All
Thank
right, to that extent.
Your Honor, our motion number 16 is Mr. Long's motion to reserve the right for evidentiary matters which would impair the integrity of an impartial jury to be heard in camera. Your Honor, this motion, we believe, especially with this particular case, is absolutely critical. I don't think there has been a hearing that we have had that has not been covered by either print media or electronic media. We understand that in Georgia, the law leans toward open sunshine and all of that. But in this particular case, the pretrial publicity has been overwhelming, and we believe that this motion should be granted in order to make sure that Mr. Long has a fair trial. It's a death penalty case. The nature of the charges are have been very much publicized, along with some of the factual allegations. It's worldwide publicity, not just national, not just statewide. And so harm, we believe, has already been done. And we want to limit and mitigate that harm right now. And in our motion, we cite U.S. Supreme Court case in Nebraska Press Association versus Stewart, 427 U.S. 539 555 1976, and it says that prophylactic measures are preferred over remedial ones. Of course, it's kind of like in court when we say objection, you say sustained, don't say that anymore, but it's already out. And so some things have already gotten out, and we think the further we go in this case, it's important to limit what gets out. And that's since once the cat is out the bag, the cat is out the bag. The harm to the potential jury pool in this particular situation is irreparable. And the best practice is not to expose potential jurors to inadmissible and or inflammatory evidence. Also, paragraph 8, we cite Gannett Company versus D. Pasquale, 443 U.S. 368, 1979 case, where the Supreme Court recognized that closure to the press of pretrial hearings may be a constitutionally required procedure. And we assert clearly to this court that closing Mr. Long's pretrial evidentiary matters is the only means by which we can avoid a clear and present danger to Mr. Long's right to a fair trial, not only in terms of inadmissible evidence, but a sense of a carnival-like atmosphere. And that's quoting Southeastern 265 Georgia 223, a 1998 case. So one of the things, Your Honor, and I know that's a burden on the court when you close the hearings, and of course, you'd have to give the media a chance to respond. And we're asking for that hearing. We're asking if the court would have that hearing, because as we move forward into evidentiary hearings, this is only applying to evidentiary hearings unless there's something that comes up in non-evidentiary hearings that we think should be in camera, we would bring that up. But we will be getting into evidentiary hearings. There's extrinsic evidence, 404B evidence, all of those things. We believe that at this point in Mr. Long's trial, those hearings should be closed, if not fully closed, partially closed, because for the defense, given everything that else has happened, we are afraid of continuing to further poison the jury pool, not just in terms of publicity, because the question the court will ask is, have you heard about it? We're worried about, have you heard about it and have you formed an opinion, which the court would ask. But just from us looking at it, none of that information that has come out has been favorable to Mr. Long. But that's not the standard. We're worried about it affecting the jury pool. But in this particular case, we're worried about it prejudicially affecting the jury pool, inflaming the jury pool, and because the sad thing about it is that if you're a Georgia citizen, Fulton County citizen, you could be in Paris, France, and you've heard about this case, or you might hear about this case. You could be anywhere in the world, and what you've heard and what you know could influence you. So we understand that that's a high bar. That's why we're asking for a hearing on it before the court would make any decision, so that we can present evidence to the court as to why the pretrial evidentiary matter should be held in camera. Thank you.
All right. Dr. Strong?
Yes, Your Honor. There are two separate matters that I'd like to address, because there are two different individuals, or two different groups of individuals, who have interests in this motion. The first one is the defendant himself, Mr. Long. And so a defendant has constitutional rights against a closed courtroom, and defendants have faulted their attorneys for not objecting to closed courtrooms before. So if any time the attorneys ask for a closed courtroom, I'm going to ask the court to address Mr. Long, for him to put on the record himself whether he is asking for the courtroom to be closed, so there will be no question that he has waived the rights that he has to an open courtroom. That's number one. Number two is that the public and the press have qualified First Amendment rights in an open courtroom and the right to attend proceedings. There are a great deal of limitations that are placed on the exclusion of the press from a courtroom, and in Georgia, those restrictions are hardier in Georgia, because Georgia is among the most open jurisdictions when it comes to the public. And so I've included a lot of very, very technical law about this area that requires there to be very specific findings before the court closes a courtroom, so that an appellate court can review it, not because the state appeals, but because the media appeals. And those they have required a great deal of specificity that has simply not been alleged in this particular case. The reporting on this case, I have not noticed anything that was inflammatory or that was irresponsible in any of the reporting that I have seen. And as our Supreme Court has said, quoting the Nebraska Press Association case that Mr. Lamar mentioned, a criminal defendant's right to a fair trial is not placed in clear and present danger by media coverage of pretrial hearings that provide the public with accurate, responsible, non-inflammatory reports of the matters raised in those hearings. Quoting the U.S. Supreme Court for the phrase, pretrial publicity, even pervasive, adverse publicity, does not inevitably lead to an unfair trial. And so nothing that I've heard today or that was written in the motion has articulated with any kind of specificity any basis for closing the courtroom that would overcome the limited First Amendment rights of the public and the press. And so the state is asking the court to deny this motion.
All right.
Your Honor, just one of the things I believe, and I was looking for in the motion, that we say that actually the DA, Ms. Willis, has actually talked about this motion on TV and granted, not this motion, but this case on television and given interviews about it. And that's from the state itself. Of course, she has the right to do that, but I think we have to take that into account when we're talking about or weighing the issue in terms of whether or not that wasn't evidentiary. What she said wasn't evidentiary. What folks say on CNN is not evidentiary. It's a difference, all right? And I think it raises a specter. It's kind of like building blocks. It's getting worse and worse here. And so we give interviews, we have media coverage, and then we have evidentiary hearings where things that the state and the defense could bring up could be poisoning to the jury pool. So I just want to take that, the court to take that into account also.
Based upon what I've read in the motion and the response at this point in time, I'm going to deny the motion. However, I may change my mind if you present any additional instances happen and I need to reconsider that. But at this point in time, I'm going to deny the motion for an evidentiary hearing as it pertains to media matters.
Our motion number
17?
I'm sorry, yeah.
Number 17?
Yes, Your Honor.
Okay.
Our motion number 17 is Mr. Long's motion for an order granting Robert Aaron Long a list of witnesses. The state has no objection to that.
All right, Mr. Armstrong?
To the extent that they are requesting what is required by the reciprocal discovery rules, he is correct. We have absolutely no objection to that. We intend to follow the reciprocal discovery rules and actually go beyond them because they are only required, they provided 10 days before trial. However, there are different matters that the state would mention. I do believe the defense's motion asks for anybody who's not included on a witness list to be excluded from trial. However, Georgia law has been very, very clear that that's more of a case-by-case basis, and when the defense is aware of an individual from discovery, that's not something that would be preclusion. So we object to them creating a new rule of preclusion that is not supported by Georgia law. Next, many of the state's witnesses are law enforcement officers. What their motion explicitly requests is information on each of the witnesses. The statute provides very, very clearly the specific information that is to be turned over for law enforcement officers, so their personal information does not have to become part of the case. To the extent that their motion asks the state to provide, to perform additional investigation on their behalf, that is not the law. We are not required to do investigation for them. To the extent the motion does that, we are not in agreement with that. I would also point out, I believe as part of the things that they were requesting us to investigate, issues involving crimes involving moral turpitude, that is no longer part of Georgia's impeachment laws, and so I simply wanted to put them on notice of that change in the law as they go about their own investigation of the case.
All right. I will direct on defense motion number 17. I'll grant the motion ordering the witnesses and direct that the parties follow the applicable statutory provisions as outlined in the reciprocal statute, discovery statute, that is. Okay?
Your Honor, our next motion is Mr. Long's motion number 18, and it is entitled, "Our motion to require the state to provide all information regarding any identification of Robert Aaron Long." Your Honor, in this motion, it goes more to just the physical identification of Mr. Long in terms of the allegations against him. And Mr. Long has also been charged with hate crime, domestic terrorism, and the state is seeking a death penalty. And we believe and we assert that information about the ID process is critical to being able to defend Mr. Long against those charges, as well as present evidence in any penalty phase presentation. As the court is aware and the state is also aware, we have the parallel responsibility, Mr. Long, of preparing, regular, not regular, it's not regular, there's nothing regular about this, but in the death penalty case, you have to prepare for the state's case in chief, where there could possibly be a guilty or not guilty verdict. And you also have to prepare for the penalty phase all at the same time. And so many times what's happening in the preparation of trial phase applies to the penalty phase. And that's what we're starting here in terms of the process, more than just that's him, that's how we got him, that's what else went into that. So that's why we're filing this motion, and that's why we're broadening it in sense in terms of what the totality of the circumstances around the idea, Mr. Long.
All right, well, why wouldn't the state be giving you all those circumstances anyways?
Well, we hope that they do, but I mean, in these cases, it's kind of like closed mouths don't get fed, especially when you're talking about killing somebody. And so that's why we have to assert that.
Okay, all right.
So,
Sure.
Your Honor, the state has turned over all the discovery in this case. We have satisfied what the law has required us. And to be entirely honest, the matters that Mr. Lamar has indicated is broadening it out to, I don't quite understand what he's asking for. And so if he's looking for additional information that is beyond discovery that we've turned over, that's something that they need to investigate, because that was far too general for me to understand what identification he's referring to other than his identification as the perpetrator of this horrible crime.
Well, we can file a motion. I mean,
Is there any additional evidence or that you think or surmise or that you can share that you think is
yes.
you think that is available that the state should be required or the court should inquire about?
Yes, I'll give you an example. All right. We believe, based on the discovery, that Mr. Long was identified by certain folks, certain people. And again, this goes to the in-camera things. But what went into that identification, how that came about, what else was said, notes, we think that is important. We think that is important at the trial phase. We think that is important, absolutely important at the penalty phase. It is not clear to us everything that went into that particular thing. So again, what the identifying witness said, how the identifying witness came to contact the police, all of those things. And I understand Mr. Armstrong may not understand, may not get it, but we're saying to the court that if we've got everything, great. But if we don't have everything, we want to say that we want to have everything. Right now, we're not sure that we have everything, and that's why we're filing this motion. But if there's nothing else to be shared, fine. We are going to investigate the case, but we're also putting the state on notice that if there's other things out here about these identification procedures that you have not given to us, please give it to us.
Well, there's a reciprocal discovery requirement. At this point in time, has the state turned over any and all known identification
Yes, Mr. Abadi turned over
evidence at this point in time?
everything that we had.
All
So
right.
if they're trying to flesh out things that they have questions about, that's for their investigation and them talking to those witnesses.
Let's put in there, Mr. Lamar, you can do an order to suffice to say that the state represents that they have tendered all known identification material as it relates to Mr. Long at this point in time. Should they receive anything more pursuant to their obligations on the reciprocal discovery statute, that they would turn over
Yes, Your Honor.
anything else? So,
Yes, Your Honor.
okay?
Yes, sir.
All right.
That concludes motions 7 through 18, Your Honor.
All right. You have motions 21 through 24, is that correct?
I have the closing on 28 is what we were set for today.
I have 21 and 24 as
I do
well.
Your Honor.
Huh?
I do as well, Your Honor.
Yeah, I have 21 and 24.
Oh, yeah. Those are, yes, we have these additional unevidentiary ones, Your Honor. Motion number 21 is a motion to produce photographs, videotapes, and digitally enhanced and processed images. Not only are we requesting what is what has been turned over in regards to just the photos that are taken by crime scene, but we're asking that we get all photos that would have been taken in regards to the investigation of this case. And the thing that I think is most often left out is we get body cams, we get the photographs that when officially crime scene gets to the location, but what we don't have is all the photographs that are taken before then. And at
By whom?
By officers, by law enforcement in this case during the investigation. I'm only talking about photos that would be within the possession of the state. And so possession as defined in 1716-1, meaning possession that is within law enforcement, the district attorney's office, and people that are working for the state on this case.
So if they say, for example, there are 3 police entities that arrive, if they search and say, well, hey, we've turned over all the photos that we have at this point that we know of, does that suffice? And to include the district attorney's office.
Yes, and to make sure that we're identifying what all photos means, because what they think is that all photos means like what crime scene photos take. But what happens is the time period between when officers arrive at the scene and when crime scene arrives is that often those photographs are being taken on their work cell phones, and they're being taken of the scene or they're doing videos of the scene. And I'm saying this not just generally, but also specifically because as the state would know from their own discovery is that in the body cam, and there is body cam footage of an officer looking at his cell phone, and on his cell phone is the crime scene photos and video that he himself has taken with his cell phone. So that is, we don't have, other than what we have on the body cam, we don't have that footage. And that happens before people go tromping through the crime scene, before they set up the crime scene tape. And so there are things that shift and move and change in between the arrival of the first officer and when crime scene arrives. So we are saying that when we are asking for all photos for them to send out, we're just asking them to send out an alert to the investigating officers if you have photos that were taken at the crime scene, whether they be on your work cell phone, whether they be taken by, some other officer that arrived at the scene, please check and send them to the district attorney's office so they can turn them over to us.
All right.
Yes, Your Honor. We have turned over everything that we know that we have. We're turned over everything that we know exists. If they have reviewed a body cam, which they've received from this case, and they see an officer pick up his phone, please contact Adam Abadi, the person who is in charge of the evidence in this case, and say, this officer's body cam, at this point he takes pictures, we want that picture. And that will give us a going point. Just saying we need all possible pictures that can exist gives us nothing to go off of when we've turned over everything that we have. And so if there are specific instances where they have reason to believe something specific exists, say if there's a police report and they say, we don't think we have evidence, we don't think we have the pictures that are mentioned on Officer Bob's report, page 3, just tell us the pictures on Officer Bob's page 3, and that will give us a jumping off point to satisfy their needs. But if we don't know what their specific needs are with specificity, we've given over everything, and we're not just going to keep going over everything to see if there's things that we don't know.
I'm worried about what I can't see on a body cam. I've been as specific as possible that I am asking for photos that were taken by law enforcement.
Do you have a date in particular that you can reference?
The date of the crime from the time the first officer arrived at
Do you have the officer's name or from the discovery that, or can you get it from the discovery that is that's been provided to you?
So so I can't, because I can know who the first officer was on the scene, but by the time the crime scene log is started,
Why don't you have a discussion with the state and determine that? I mean, I think that what the state's saying is they'll satisfy it, but you've got to help them out with a little bit more particularity. They're referencing to the court that, hey, we've turned over all the photos that we have that are known in our possession. If you believe there's something else, then show us or let us direct us to that particular point so that we can make an inquiry that is not just kind of just saying, well, hey, anybody and everybody. So,
Certainly. So we'll make a list of the officers that were at the scene, and those are the officers that we would be asking them to ask that if they took pictures on their cell phones, to make sure that those are turned over in regards to the investigation in this case.
Your Honor, may I add something?
sure.
As Ms. Bell gave in her example, if an officer who has body cam is there and picks up his camera and starts taking a picture, you'd see that on the body cam.
Yeah.
And we've turned over the body cam. So if that happened in this case, they can tell us this officer does this at this point. There's no reason for us to do this. If they want to ask witnesses if certain things exist, they are free to contact that individual.
Yeah.
So just to be clear, because that's a misrepresentation, I have viewed the body cams. We do not have body cams of people arriving at the scene.
I'm sorry, you don't have body cams of who?
Of officers arriving at the scenes and what they're doing when they arrive at the scene. So the reason I know this is because I viewed the body cams in this case. And I'm not asking the state to do anything other than make an inquiry. So literally the duty that I'm asking the state to exert is to reach out to what is considered in their possession and send an email.
Okay, they're telling you already they have turned over everything.
Correct, but they
Okay,
haven't.
so
My apologies.
if you want something else, I mean, it's like double tap. I mean, if you're going to go, you're just asking to do it again for what reason? I mean, to make sure that you have everything or what?
Well, we don't have, the images that I'm talking about, we don't have. I am happy to send the list of officers, as Your Honor has suggested, to the state so that they can inquire if they've received cell phone footage from them. We have not received any cell phone pictures in this case, none.
Okay, and you believe that officers have taken cell phone photos?
I believe from the fact that I saw an officer looking at a video that he took, that yes, that they took them. And it is routinely, it's been written about in journals on law enforcement to use their cell phones so that they can capture the freshest image of the crime scene.
Okay. Mr. Body.
Thank you, Judge. I had made that inquiry through the lead detective previously with Detective DeMeester. But if defense counsel would be kind enough to at least identify just the specific body cam, and because I know the list of responding officers, I provided the discovery, but if they can provide me as to the body cam that they're referencing, that they see the officer taking photos or videos, that would help me narrow it down, and I could probably identify the officer individually.
How many officers do you have that responded?
There was probably 50. It was a pretty hectic scene where there were a lot of officers and a lot of force that was that responded due to the multiple scenes in close proximity to each other. And most body cam has timestamps, so the referencing of the body cam and then the timestamp or where she believes or defense counsel believes.
Okay, body cam is one thing. What I think she's asking for, just to exhaust, is the issue of photos.
Yes.
So why don't you just send out an inquiry that you can do this. The order should say that the state has referenced that they have, or represented that they have turned over all known photo and digital media or enhanced media at this time. However, the defense shall provide a list of the state will inquire as to whether or not in their work or individual possession any other photographic or media evidence exists. How's that?
Yes, Your Honor.
So you need to provide them a list.
Yes.
With the people that you think, and then Mr. Abadi and Mr. Armstrong, Mr. Carlson will just send out an inquiry and determine whether or not there's anything else that was taken.
Yes, absolutely.
Okay, all right. Anything else as it pertains to Defense 21?
Nope.
All right, let's move on to 22.
That's our motion for disclosure of GPS, phone tracking applications, and other electronic surveillance that was used to track the movements of Mr. Long. We have received some of what I think was one of the primary uses to track Mr. Long in this case, which was an application, but we don't have any of the underlying data of that application. So if the state has that, then we're asking them to disclose that and how it was used, and if any other applications were used to track him, we're asking that that be disclosed as well.
All right, sir.
We've turned over everything that we have. If they have reason to believe something specific exists and they can tell us the specific basis, that will give us a chance to see if we have that. We have no reason to believe that we have anything other than what we've turned over.
All right.
If we can send something particularized in regards to what might be underlying. The application is not, that the police used is not, it's not based in the United States, so I don't know if they were able to get anything. And so that's why I'm asking, but I'm happy to particularize what we know and see if the state received any additional information.
All right, again, state's reference or proffered that they don't have anything. They've turned over all GPS, phone surveillance, and other monitoring evidence. If you have a particularized list, you can put it together. That would also probably come up if an expert testifies as to location. Mm-hmm. They're gonna need to have all that data anyway. So you can put that in your order, and we'll see if there's any further inquiry that needs to be made out of it. Okay.
Thank you, Your Honor.
All right. 23.
Motion number 23 is a motion to inspect, examine, and to test physical evidence. And it is for the purposes of being able to review and examine the physical evidence that was gathered in this case.
Have you talked with the state about setting a date for you to do that?
Not yet, Your Honor.
Right.
We expect to do that with them.
Okay. Mr. Armstrong?
Yes, Your Honor has anticipated a lot of the state's response, which is, number one, they use the word produce. We have to make available to them. We don't bring it to them. We don't give it to them necessarily. We have to make it available to them for their inspection. Now, as has been the case the whole time, we've asked that if they wish to inspect anything, to contact Chief Deputy Abadi to set up a time for that. However, we've also specifically noted that for things that the GBI has, that there's a separate statute about contacting the GBI, and so I've directed the defense to that statute. So if there's anything that the GBI has, that they should contact the GBI to set that time up, because we can help them facilitate that, but we are not in control of those things.
All right. Ms. Bell, do you have a date in mind that you'd like to, or dates in mind that you would like to go ahead and do a physical inspection, or the state make available, term of art, the physical evidence in this case? Did you have a date in mind you want to do it?
I don't have a date in mind to do it at this time, Your Honor, because one of the things that needs to happen is that in dealing with the GBI, because the
No. I'm going to move to the GBI in just a second, okay? I'm talking about the state of Georgia, the district attorney's office in Fulton. Do you wish to set a date with them in my presence right now? Because what I was going to suggest for the GBI is that you put in the order that you follow the statutory procedure and/or utilize the district attorney's office to facilitate inspection of that particular evidence.
that's exactly what I was going to suggest, because typically the GBI will send it back to the state so that we have it all available for a viewing. And so I don't have a specific date. I would have to say that after I have a trial in May, so it will be after that trial that I will.
After we have the motions, I tell you what, then why don't you do this? Prepare a suitable order for my signature and just put in there that you'll set a date
at our motion.
On May the 20th of this year.
Yes, I can do that, and I'll be prepared to set the date and time. And
then I'll set a pinpoint date based upon what you all tell me at that point.
Yes, Your Honor.
All right. And motion number 24?
Motion number 24 is a motion for disclosure of favorable information. It is our preliminary Brady motion in this case. And I say preliminary because as we may discover something exists that we think exists that might be Brady that the state has not turned over, then we will reach out to the state and serve a particularized motion in regards to that. But that only satisfies one side of the duty. The duty is also on the state to turn over anything that would be potentially either exculpatory or would lead to something that could be favorable to the defense. There is two misconceptions that I want to just clear up in regards to how the state responded to this. First, Brady is not discovery. Brady is something that is separate from discovery. Discovery is outlined in a statute. Brady talks about something that has to be determined based upon the entirety of the information that the state has. It is something that could potentially be favorable or lead to something favorable. What the other misconception that often happens with Brady evidence is that it has to somehow move the needle toward an acquittal, or that it would have to be something that would change the verdict in this case. That's the appellate standard, that's not the trial standard. And so the trial standard is anything that would meet the obligations of Brady, Giglio, and its progeny. And so that includes impeachment information, that includes information that the state may have about their witnesses, about the case, that would be turned over, that would need to be turned over. And it includes information even that they may have about whether the victims have said that they don't want the death penalty in cases. That was the story case out of Texas that was reversed for the failure to disclose that, and that the court found that was a Brady violation. So there is a number of issues that I think are covered by Brady that are not sufficiently addressed in the way in which the state responded to what Brady is. So under Brady, getting back to the defense's obligation, is that we satisfy our obligation to make a specific request by filing this motion. As the appellate courts look at it, if we just do a blanket, two-sentence, motion, turn over everything that's Brady, that doesn't satisfy a further inquiry on appellate level of whether or not we did our obligation to look in all the areas of which it may exist. And so, like I said, this is the first of what may be more Brady motions if we come up with something that we need the court to look into or need the state to look into, but that's why we filed this motion.
All right, madam. Sir?
Yes, Your Honor. The state doesn't quite understand the representations about the state's response. We are complying with Brady. We've turned over everything that we have that is germane to discovery. She's now mentioned the story case. I'll go look at that. I don't know if there's anything that has happened in this case that would be germane to that, but I will look at that one particular case to see if there's something in addition to what I understood discovery to include, and to include constitutional discovery. But we are complying with Brady. To the extent the defense says that making this request absolves them of having to do their own due diligence, that's incorrect. This motion is written, asks the states to do investigation for the defense. I do not have the defense motion directly in front of me at this moment because I was relying off case management. They have many trees. And so with case management down, I don't have their specific response in front of me. However, as I recall, and as I included in the response, they had asked the state to go do things for them. That is something that is the law does not require. And for the purposes of Brady, the prosecution does not suppress evidence by refusing to conduct a search for it, even though the evidence may be more accessible to the state than the defense. That is a Georgia Supreme Court case that has been affirmed in other respects since 1984 when that was first decided. They still have due diligence. And so I would, just as a way of going about that, I would mention that just saying that the state has turned over everything and so we don't have to look for anything else, they still are on notice of different things, which is why I've drawn attention specifically different times to, we have specific reason to believe that this exists in the custody of the state. There's one famous case where the state turned over discovery, but in the copying machine, pages that had been front and back weren't copied front and back. And so the defense got an odd report that only had page 1, page 3, page 5, page 7. And that was considered not to be a violation of Brady. It was ineffective assistance of counsel because the defense would have been on notice that there's things that they were missing that to request. But again, things that they believe might exist in this world that they can go investigate that we do not physically have, that's not something on us to do, that is on them to do. The fact that we brought a death notice does not absolve them of their due diligence to do their own investigation.
Okay.
So I just need to correct a couple of things, because I think and I hope that Your Honor heard what I heard in Mr. Armstrong's response was discovery, discovery, discovery. We've turned over everything in discovery. As I first stated, Brady is not discovery.
It's a separate category.
It's a separate category.
All right.
And so that's the first thing. The second thing is this idea that, we're asking people to go out and do investigation for us. We're perfectly happy to do our own investigation. The motion that we provided, this idea that, that our motion there is asking you to go beyond the law, every single thing that we put in our motion has a citation to a case where a court found that it falls under Brady. So I don't know what else is within the law, if not a court finding that something that we've listed is Brady. So we're not making these wild, requests and wild requests in our motion. So those, again, I'm perfectly satisfied with an answer from the state that misinterprets Brady, because that only helps us on the appellate side. But I want the court to be, and the court has clearly stated that you understand that should we be filing motions as we continue to investigate for things additionally in regards to Brady, that we have laid the foundation as to all of the areas we think applies to Brady.
All right. Here's what I'll do. You can prepare an order, Ms. Bell, to the extent that the state has complied with discovery to include separately Brady material, and that should they come across any additional material that would be responsive to Brady, consistent with the things that you've asked for, that they will notify you immediately and turn said material over. Okay. So can you prepare an order to that extent?
Yes, Your Honor.
Okay. All right. Okay. I think that we've exhausted those particular motions, 7 through 18, 21 through 24, and I believe what's left is argument by you, Ms. Bell, on motion number 28.
Yes, Your Honor. Could I just have 1 minute to run to the restroom before we start?
Okay. I wouldn't take 5.
Or not.
We'll take 5
It will be
minutes.
faster.
We'll take 5. We'll be in recess 5 minutes. It's all right. Okay? We're in recess. Adam,
Yes.
go right ahead.
So there's two issues that we have to discuss in regards to motion number 28, which was our motion for extension of Roper versus Simmons, an evidentiary hearing that was held in September 29th. The first issue was the court asked the parties to, well, the state responded to, in their omnibus response, they objected to the Roper hearing, the Roper extension motion being held, the hearing being held. The court asked us to put our position in a written motion. That motion was filed on October 13th of 2023. And so that's the first issue. And then the second issue is our closing arguments on the motion itself. In regards to that motion number 28B, I know the court has it. I know the court has reviewed it, but I brought it. And if the court wants me to hand it up, I cite Dawson versus the state, also Moore versus the state, which is 274 Georgia 327. It's a 2001 case.
Oh,
Copy from the state into the court.
can I make an announcement that might truncate some of this? I don't object to the court to having heard all of the evidence ruling on it, because the issue was about not having to have all the evidence presented. That presentation wouldn't have been necessary if the court had ruled that a proffer would be fine, but having heard all the evidence, the state no longer objects to the court ruling on the issue.
Okay.
I will hold on to that. So then if the court would like me to go through the argument, I'm happy to do that. Because it gives the court the reason why this court can rule on this motion and if so chooses, rule in favor of the defense.
Okay, so give me the bottom line up front. What are you asking me to rule? What are you asking me to grant you?
In overall,
For motion 28.
in motion 28, what I'm asking the court to...
Because if I understand it correctly, the state's not objecting to the evidence, so...
The state's not
That's coming in right now, so they're saying that I have the ability to rule upon that at this point in time.
So the bottom line, and then I will lay out the reasons why, is that we're asking the court to find that there is sufficient evidence to support the fact that late adolescence brain development is more like juvenile brain development than like an adult brain. That evidence was presented at the hearing on September 29th, and as a result, it is appropriate at this time in 2024 to determine that the same findings that the court had in Roper versus Simmons exist based upon new science and new evidence, and up until the age of 23. And I wanted to make sure that I was able to provide the court with the range that we're asking for, and then I can support the reason why in my argument.
Okay.
And so that's what we're asking the court to find. We believe the court has the authority to do that. That's laid out in a number of the cases that are cited in our motion, that the court has the authority to make a determination about the constitutionality of a particular statute in application to the cases in front of it. It is also, which is one of the great misconceptions about when this and other motions like this are brought, there's this misconception that this issue can only be considered by the U.S. Supreme Court and that ruling be made, and that is a falsehood. That the court that is hearing a case is granted the constitutional power to make decisions about the case in front of it. And that includes the constitutionality of the statutes, and that includes the constitutionality of the sentencing statutes, as is laid out in my motion number 28B, where I cite the court to specifically, besides Dawson, to KOLOKOURIS, Colocoris versus the state, and it cites to a number of other cases in that case, and also Brinkley versus the state. It's in the motion. So I do believe that the authority for the court to make the determination, and then the reason I cite Dawson is because there's an obligation for that to be heard and ruled upon by the court. Dawson very clearly laid out that all of the defendants where the court had heard and ruled upon the motions regarding their challenge to electrocution at the time would receive the court's ruling, the benefit of the court's ruling. However, there were about 6 cases where that had not been done or had not been done properly, and that those are excluded. So that court's finding, the Georgia Supreme Court's finding in Dawson versus the state, is also the authority. So in this case, we start with Roper versus Simmons, which asserts that the reason why we have this expansion of the Eighth Amendment is because it's meant to be changing over time. And as the Roper court said, like if it was meant to be frozen in place, that we would still be executing 7-year-olds. But it's not. It's meant to change over time, and it's meant to change in different ways by the court's analysis. And so the reason the court heard so much science is because that is how the court's analysis has changed over time. If you look at Thompson versus Oklahoma, which was where we started at the age of 16 in 1988, the court in that case decided it based upon what is the national consensus. What do people think about, executing 16-year-olds? Is there changing in laws that we need to look at to determine that? And in fact, once that the court found was that there was a national consensus that it wasn't permissible to do it, which is why Thompson versus Oklahoma was ruled in 1988. In 1989, in Stanford versus Kentucky, that was denied because they felt that there wasn't a national consensus. And the reason why we know that this is the way in which the courts were deciding these issues back then is because the same year in 1989 was also when Penry versus Linnau was heard by the U.S. Supreme Court on the issues of intellectual disability. The court made the same analysis. Is this a national consensus issue? So then what we know is that this all changed by the time we got to the 2000s. Because in 2000, we have Atkins where the court says, we're looking at the science. What does the science tell us about intellectual disabilities and whether or not those people should be subject to the death penalty? That was in 2000, and then followed by Roper in 2005. And by the time we get to Roper, the court does look at issues across the country in helping them make their decision. But what they decide ultimately is they decide in 3 different areas that they are going to exclude 18 and below from the death penalty because of the scientific advancements. The first area was that the scientific and sociological studies showed that there was a lack of maturity. There was an underdeveloped sense of responsibility, and that those qualities lead to impetuous behavior. The second area was that they were more vulnerable and susceptible to negative influences. Again, dealing with looking at neurodevelopmental advancements of juveniles at that age. The court cites to an article that we put in the binder of articles that we provided to the court, less guilty by reason of adolescence, developmental immaturity, diminished responsibility, and the juvenile death penalty. That's what the court relied upon for that second area. And for the third area, the third difference that they noted was that the character was not well formed of that of an adult. And they relied upon work that was done around personality traits of juveniles being more transitory and less fixed. So that's what the court decided in Roper versus Simmons, all based upon the science that existed at that time. And so as a result of that, the court found that because of the diminished culpability of juveniles, and they recognized that it didn't meet the peniological justifications for the death penalty. And so the court decided that the age of 18 was also, they also looked nationally and said it's also a point where society draws a line for many purposes between childhood and adulthood, and we conclude at the age of the line for the death penalty at that point in time. So what's interesting about this change is that they relied on their opinion for the science. They looked nationally, but they didn't look nationally about opinions about the death penalty. They look nationally about how society considers 18-year-olds and how they treat them. And so, that's essentially a little bit of the history of where we got to now. So the question is, why am I saying that now is the time to make this decision? Well, first, it's been 18 years. So the difference, the difference between Thompson and Roper was 15 years. It was almost a generation to determine the scientific differences between where juveniles were when they decided Thompson and the evidence that they were able to put on in 2005. 18 years later, there is a host of new evidence. There is scientific evidence, there is different ways to test it, and so all of those scientific areas are now able to provide information for the court that was not available in 2005. And so what I would cite the court to is that the way this is being looked at by other courts is that there is a contemporary standards of decency in regards to this. And so there are a number of courts that have been looking at this issue, and there is the Kentucky case, which the state cited in their response, saying that, this was, decided, and then it was reversed by the court saying that it wasn't ripe, and they were making these findings. But what I would say that is most important about that is that they did not find that the science was wrong. They found that in their idea that this was not a right issue based upon Kentucky law. And as I cited in my brief, that is not what's applicable here. So in this contemporary standards of decency, it has been found that the brains of emerging adults are not fully developed, and that's the same as late adolescent period, and are more similar to those of juveniles than older adults. And this was recently found for the issue of automatic life without parole for juveniles. Commonwealth versus Mattis, M-A-T-T-I-S. It's 224 Northeast 3rd, 410. It's a Massachusetts case. It was decided in 2024. And in that case, this court in Massachusetts heard the same evidence and the same type of evidence that Your Honor heard. And they made a finding that based upon, and Massachusetts doesn't have the death penalty, based upon that, based upon the evidence that they heard, that it was unconstitutional for between the ages of 18 and 20 for juveniles to be subjected to, and the late adolescent period to be subjected to automatic life without parole. So I have a copy of the case that I'd like to hand up to the court.
Okay. Yes.
In Commonwealth versus Mattis, the court said, in particular, that emerging adults, which is the same as a late adolescent period, they identify that within in the briefing, that's what they're talking about, are less able to control their impulses, that their reactions in emotionally arousing situations are more similar to those of 16 and 17-year-olds, and that than they are to those 21 or 22 or older. They also found that all of the experts that were presented, in that case, including the Commonwealth's experts, agreed that the prefrontal cortex, the area of the brain associated with controlling impulses, is among the last brain regions to develop and continues developing until the early or mid-20s. This court heard in the evidence that we presented over and over again that the executive functioning is like the CEO of the brain. I think we were all like tired of hearing that by the end of the hearing. But there's a reason why it is so important to note that. And there's a reason why the court referenced in their opinion that even the Commonwealth's experts in the Massachusetts case agreed that the prefrontal cortex, the area that is controlling impulses and making decisions, is less developed. The other thing that I think is of import is for the court to note that they did an analysis about where the same kind of analysis that the Roper court did of what the rest of the country looks like in terms of this emerging adolescence area. And what they noted was, for example, that DC provides a chance at sentence reduction for people who were under 25 when they committed a crime. That California has extended youthful parole eligibility, youth offender parole eligibility to individuals who committed their offenses before 25. Colorado, where there's a specialized program eligibility for juveniles, they do it up to 21. And also in Wyoming, where they revised their alternative sentencing for those that were under 30. So they did this analysis to determine whether or not there was, this other national trend for addressing age in regards to those things. And so more recently, what I think is helpful is to understand what the U.S. Supreme Court requires, I think, in terms of issues like Roper, like Atkins, in terms of determining it. And in Hall versus Florida, the court said that this court, state courts, and state legislatures consult and are informed by the work of medical experts in determining intellectual disabilities is unsurprising. Those professionals use their learning and skills to study and consider the consequences of the classification schemes they devise in the diagnosis of persons with mental or psychiatric disorders or disabilities. And I think the same thing applies when we're talking about brain development rather than brain impairment, because the brain development is what matters when it comes to whether or not someone is considered less culpable. Impulse control is one of the things that we talked about, and that the neuroscience that the court heard about talks about emotionally charged situations, which would be any time that something creates this sort of interpersonal event that results in a case that would be a death penalty case, and that they take more risks. That is all of the science that we were talking about here. So the death penalty is long recognized as the most severe and irrevocable of punishments. There is a greater capacity for change from the ages of 18 to 23. And that is one thing that was less examined by the Roper case, because this data that the court heard did not exist at the time. They talked about the development of the brain, which would develop the personality, and it was one of their factors, but it didn't have the science that Your Honor had in this hearing that we presented. Character development matters. Who someone is matters in a death penalty case. And what is new since Roper is that you got to determine, you got to see where people end up when they have been tested as juveniles and then later presented to, looked at as adults and over the age of 21. And when someone is facing a death penalty, it is absolutely the decision of the jury when you get to penalty phase as to who this person is. So the idea that we could not know is not constitutional. Although someone could argue that 21-year-olds who have violent traits, it's more categorical than transient, we know, at least from the data that this court has heard, that it's impossible to know if whether or not that reflects the true and enduring character of someone when we have not seen the actual full development of their brain. We, in the work that I do, in the work that at least many of us see in the courtroom, when we have cases that last over time, we often see people come in one way, and then years later, they are presenting, acting differently as they get older. I have clients that I have seen go from, the most important thing when they're arrested is the fact that their gold teeth were taken. And then, 6 years later, this person is talking about, what a future looks like and what actual future planning is. That's brain development. That's something that we see personally. That's something that we see within the system. And it makes a difference when you're deciding who somebody is. So I'd like to just briefly talk about the evidence that this court heard, because I want to point you to some of the articles that I think are most relevant of the ones that we submitted. As this court is going to determine whether or not this is the evolving standards of decency, I think it's important to hear and to consider what the U.S. Supreme Court really thinks about the reality of where the Eighth Amendment stands and how we should be considering it. And just recently, Justice Sotomayor wrote a dissent in the Smith case, which I think everybody's fairly familiar with, was the execution of Mr. Smith via a gas chamber in Alabama. And in her dissent, she wrote, "Not long ago, this court remarked that the Eighth Amendment's protection of dignity reflects the nation that we have been, the nation we are, and the nation we aspire to be." That was Hall versus Florida. And what she noted was that that case, the one in Alabama, shows how that protection can be all too fragile. And I think that often, and for years, we see that the Eighth Amendment is dismissed as something that is just trying to make things more favorable for criminals, or for criminals to get off, or for things like that, rather than an actual application of the science about who we are and what we know about juveniles and development and things like that. Because our goal is to punish appropriately people that are charged with these crimes. The first thing that I think that the court, I would direct the court to, I think is important, is to note that all of the evidence that we talked about was neuropsychological testing, clinical neuropsychological testing. And there was an article that we included called "The Trajectory of the Development of Executive Functioning, Implications for Death as a Penalty as Applied to the Late Adolescent Class." It is an article that notes that clinical neuropsychological testing results have been well accepted in settings such as medical, educational, and legal arenas. Neuropsychological testing requires the assessment of multiple neuropsychological domains, but the most important of all the neuropsychological domains has been the executive functioning, most likely because it relates to the expression of human adaptive abilities and problem solving. Essentially, it is whether or not people can make decisions, make judgments, and overcome impulse issues. And that article is cited in there. For the measures of executive functioning abilities from the tests that were given and that have been given uniformly across the field, that they peak in the early 20s, between the ages of 20 to 25. The second area is, which I think is important, is the emerging trends. And this takes up the factor of Roper, where they were like, what other areas rely upon this science and make decisions based upon it. And that is trends in law governing the behavior of late adolescents up to 21 since Roper. But the article goes beyond 21, which I would also note, is that they point out examples, like for example, I think one everyone knows is that, in renting a car, they no longer say 21's good enough for renting a car. I think that they want to get their cars back in one piece more. And they know that that the later that the requirement is, the less likely that there is going to be impulsive, risk-taking, or dangerous behavior. Another thing is that, what I found interesting is that that to be an FBI agent, you have to be at least 23 years old. That is where they have raised the level to be is at 23. And that article notes that federal and state governments have maintained and enacted laws demonstrating a societal consensus that people under 21 need to be protected from their own high-risk behavior. The public at large needs to be protected from the immaturity and impulsivity of those under 21, and that those under 21 are in certain contexts considered minors who must be supervised by adults. That's just looking across the board at things. But I think what's most important and is so very different from what the court had available in Roper versus Simmons is the brain development. And there is an article that we provided called Development of Brain Behavior, Integration Systems Related to Criminal Culpability from Childhood to Young Adulthood. Does it stop at 18 years? In that article, they talk about the brain studies that have been done, including some of them are the largest brain studies that have ever been done. This article is by Dr. Reuben Gur, who is well known as one of the foremost authorities in analyzing brains through MRIs, fMRIs, and PET scans, and looking at the actual imaging of brains and doing them over time. He is also, as it's all noted in the article, the studies that he's done, he did the largest study of soldiers that has ever been done to look at the impact of when soldiers that have returned from service, that to look at the impact of brain and brain issues and effects of all sorts of trauma. So he is, as an authority in this, and this is where I get my authority for the court in regards to what we are asking for. And in the article he says, "Here I present methods used by neuroscientists to measure parameters of brain development related to complex behavior and summarize the major findings in this article." What he finds is that I conclude that this, jumping to his conclusion, I conclude that this 18 and older population, probably up to around age 23, is therefore just as vulnerable to the effects on behavior, especially behavioral control, of the lack of maturation of these brain structures and functions as are 17-year-olds. Notably, since brain development in the relevant areas goes in phases that vary in rate, it is usually not complete before the early to mid-20s. There is no way to state with any scientific reliability that an individual 20 years old has a fully maturated brain and should be eligible for the most severe punishment, no matter how many otherwise accurate tests and measures may be applied to him at the time of his trial for capital murder. And so when you have that kind of science that attaches to what the development of the brain is, to the neurological studies, and then you have the work that Dr. Kaufman did. And what I think is most, stunning about the work that Dr. Kaufman did was she presented a chart that is in the PowerPoint that I provided to the court, where she talked about over time, people that had a violent felony in the years of 14 to 17 years old, that over time, when they did a study, it showed that the majority of them did not reoffend. And that over 90% of adolescents engaged in violent felonies in their late teens will grow and mature and almost completely desist from criminal behavior. So that if you were to determine that based upon the act committed by somebody in that time period that is in that class of the developing brain, if you were to determine that that is the fixed and intransible quality of who they are and who their character is, then you would be 90% chance that you would be wrong. 90% chance that you're wrong. And that, I think, is the most compelling argument for putting someone in that stage before a group of people and saying that they need to make a determination based upon, who they were during this period of time where their brain is in that period. The APA in their resolution, and this is all in the record, said that the death penalty for late adolescent class is typically based upon unreliable determinations of members' current culpability status and even more unreliable predictions of their future potential. There's always, often, arguments about future dangerousness, and it is completely unreliable as resolved by the APA. The last thing that I think is really important for the court to know is that there will most certainly be argument about what Roper is and what Roper is not, and what the court can and cannot do in regards to that. So I'd like to be clear about what Roper did not decide. Roper did not decide anything about a national consensus against capital punishment for the late adolescent class. They never have, neither Roper, the Roper court, the Supreme Court, or any other court has directly addressed a national consensus against capital punishment for the late adolescent class. So that has not been decided, except Massachusetts in favor of the extension. No other court has addressed whether those in the late adolescent class possess or do not possess diminished culpability. That has not been decided by the Roper court. So for the state to stand up and say that Roper has decided against this, they have not. This is all new information. And no other court has said that the information is wrong or inapplicable in this case. No other court has decided except for Massachusetts, and they decided in favor of this. Similarly, no other court has addressed or ruled against whether there is a mismatch between culpability factors and the penological goals, as the Roper case did for under 18. No U.S. Supreme Court or any other court has ruled against this. The only court that has ruled, Massachusetts, has ruled in favor of this. And so I cite that to make it clear to the court that not only is this the time to do this, not only does the science support it, but the court also has the power to do that. The power to make that decision. One second. I lost my...
Take your time.
And so I think, so again, just to make sure that I've covered everything, the ask is for the court to find, oh, yes, I think I need to put on the record and note that there was no contrary evidence that was provided by the state. They provided no doctors, they provided no evidence that was contrary or could dispute the doctors that were put on here, similar to the Commonwealth case where the experts had to agree about the development of the prefrontal cortex. That the record in this case is the doctors that testified on the 29th. So there is the request is for the court to find that there is sufficient scientific evidence and data that the development of the late adolescent class, brain development of the late adolescent class, that is affected in areas that the Supreme Court in Roper versus Simmons found made juveniles less culpable in their finding of 18 and under, in the area of impulsivity, in the area of being susceptible to peer influence, and in the area that their brain is not fully formed, making that their culpability level not meeting the peniological goals of the death penalty. And as the Roper court said, that from a moral standpoint, it would be misguided to equate those failings of their development the same as one would for an adult. I'm happy to take any questions if the court has any.
No, ma'am.
Otherwise, I'm accepting.
I'm good. Thank you so much. All right.
Yes, Your Honor. May it please the court. I was going to go in the same order as the state's addendum that was specific to this motion as far as argument is concerned, but I'm going to begin instead with Commonwealth versus Mattis. You heard Ms. Bell say that there is no other case but the Massachusetts case that addresses the issue that they say is before the court. The Massachusetts court did not address the issue that is before the court. The Massachusetts case said very specifically that it was considering whether to apply its own state constitutional decisions to emerging adults, that is, those who were 18, 19, and 20 years of age when they committed the crime. That does not apply to Mr. Long. Mr. Long was not 18, he was not 19, he was not 20. I believe he was a few weeks away from being 22. He was at the end of his 21st year. In addition to that, I would like to emphasize that they were not making a decision under the Eighth Amendment. They were making a decision based on their state constitution, Article 26, which they determined provided more protections to individuals in these age classes than the United States Constitution does. Now, obviously, their claim applies not just to the United States Constitution, but to the Georgia State Constitution as well, because we have protections against improper sentences as well. However, in the brief time that I have had the Massachusetts case in front of me, there are wildly important differences in how Massachusetts treats individuals in Georgia's, that is important to their state constitution. They already had decisions saying that their state constitution was considerably broader than the United States Constitution. In addition to that, they had specific legislative actions by their government to address those individuals in the class of individuals which the case was considering. At one point, the article talks about the legislature has determined that emerging adults require different treatment from older adults, specifically in the penological context. They then cite specifically that it is statutorily authorized to maintain custody of young people adjudicated as youthful offenders up to 21 years of age. I will point out that for individuals who are convicted in superior court, if they are convicted of felonies as adults, they are given to the Department of Juvenile Justice to be turned over to the Department of Corrections when they turn 18. And so you don't have the same type of laws that the legislature has imposed in the treatment of individuals who are 18, 19, 20, or in the case of Mr. Long, 21. And for that, I would cite OCGA 49-4A-9. It is a case that the Supreme Court has, it is a statute the Supreme Court has addressed at least somewhat in a case involving a defendant named Timothy Hudson. I don't have the citation for Your Honor because this is new information that I have in front of me. And that was about things that the court could do at that point in time when you're turning 17, essentially, that the court can do to address your sentence. I would also like to point out that the Massachusetts case was not deciding that it was impossible to impose a life without the possibility of parole sentence for 18-year-olds, 19-year-olds, and 20-year-olds, but whether it was improper for it to be automatic. In a case such as this, Mr. Long, should he be convicted under the guilt-innocence phase, he will go to a penalty phase that is very specific to his individual circumstances. That is exactly what he will be getting. He will be getting an individualized determination by a panel of his peers on whether the death penalty is an appropriate sentence or not. And if there are deficiencies that they believe exist in his mind and his ability to process information and to do other things, they'd be able to present information to the jury to try and convince them that he is not deserving of murder for his actions that he committed at the age that he was. Now, I apologize if I did not make it as explicitly clear when I thought I did. I thought that after we had the evidentiary hearing, I had mentioned that I was no longer objecting to the court ruling on the issue because my main complaint was if we didn't have to have the hearing, we didn't need to have the presentation of evidence. But with the presentation of evidence, there's no reason not to have the court rule. However, the court is nevertheless bound by the Roper decision. The Roper decision did not determine simply that people under the age of 18 are ineligible for the death penalty, such that possibly 18, 19, 20, and in Long's case, 21-year-olds are ineligible. No. Roper said specifically, we conclude the age at which the line for death eligibility ought to rest, that was the end of the quote, is the age of 18. They said that is the line. For the United States Constitution, this court does not have the authority to change that determination. You can build a record, absolutely, that this defendant can take up to that court should he be convicted and sentenced to death. But that's not a ruling this court has the authority to change. As the Fourth Circuit determined in the Dylan Roof appeal just 2 years ago, in which they said if the Supreme Court precedent has direct application in a case, as Roper clearly does, then we must follow it. And that was in a case where an argument was being made that Dylan Roof, who I believe was younger than Long at the time of his crimes, was ineligible for the death penalty. You heard arguments about Atkins and about Roper and the evolving standards of decency. In both Atkins and Roper, the Supreme Court of the United States pointed to the national consensus about different states who have the death penalty and whether they have exclusions for the death penalty for individuals who are under the age of 18 in the case of Roper, and for individuals who are with intellectual disability, which was the case in Atkins. We can reference to the law itself, but I also mentioned that when I talked to one of the experts and asked them how many death penalty states preclude someone like Mr. Long from being executed based on his age, the answer was 0, because that's what it is. The national consensus for jurisdictions that authorize the death penalty, 0 have enacted by popular means what the defense is asking this court to do here today. Also, I'm not going to go long into it, but it was mentioned in Roper, international norms. Having a 21-year-old excluded from the death penalty for a jurisdiction that has it would violate international norms, which is mentioned only because that was one consideration that they mentioned in Roper. I already touched on this somewhat. The state constitutional rights that are at issue, I am not aware of any decision similar to those in Massachusetts that says that our version of the Eighth Amendment is much more robust than the Supreme Court of the United States' determinations for the Eighth Amendment. And indeed, our state Supreme Court has said that legislative enactments constitute the clearest and most objective evidence of how contemporary society views a particular punishment. And again, there's nothing that the Georgia legislature has done that indicates that a 21-year-old is not held as culpable as a 25-year-old or as culpable as a 29-year-old when it comes to what is available as the sentence imposed for their crimes. Indeed, in the instances of Atkins and in Roper, or at least Roper's prerequisite, Georgia was typically ahead of the U.S. Supreme Court in finding that it was inappropriate to execute those with intellectual disability, using a different phrase at the time, and against executing individuals who are too young. Although we did not have the 17-year-old component, we were much far in advance of the Supreme Court for people who are under the age of 17. You heard Ms. Bell argue at length that Roper doesn't address the issue today, and it really does. They set the line at 18, but beyond that, the Supreme Court cited research that indicated that individuals still have development up to their mid-20s. Roper had that information before that because the APA's amicus brief in Roper, which you heard their experts tout, included that information, and I have citations to that in the state's response. Also, I have a passage from Roper versus Simmons. I'm going to read it, and I'm going to highlight one sentence afterwards. This is a passage in which the Supreme Court acknowledged that defendants like Mr. Long could make arguments like this today about the cutoff line being 18. Drawing the line at 18 years of age is subject, of course, to the objections always raised against categorical rules. The qualities that distinguish juveniles from adults do not disappear when an individual turns 18. By the same token, some under 18 have already attained a level of maturity some adults will never reach. However, a line must be drawn. That is, with the information the APA provided to it, acknowledged that 18 is not a magical line as far as development is concerned, and yet still set the line at 18. More on that, I asked every individual who testified on behalf of the defense if they agreed with that middle sentence. The qualities that distinguish juveniles from adults do not disappear when an individual turns 18. All of them agreed with that. I mentioned that because what they are saying is not something that is inconsistent with what Roper decided or with how Roper decided it. I also point out, as one consideration which was in Roper, is that the federal government permits individuals in these age categories to receive the death penalty. And as I argued before to this court, that includes Dylan Roof, and that includes Dzhokhar Tsarnaev, both individuals, high-profile individuals who are younger at the time of their offenses, who committed multiple homicides. In both Circuit Court of Appeals cases that have decided their appeals, they have rejected claims similar to these, and indeed the U.S. Supreme Court actually reversed one of them when the lower court had vacated the death penalty due to a jury issue. So this is an issue that courts have considered but rejected. And so with all of that information, you indeed heard that there is no court to have decided the issue that they are asking the court, except for Massachusetts, and Massachusetts didn't decide this issue. It did not say anything was restricted as to individuals who are 21 years of age, such as Long was at the time that he killed 8 individuals for no good reason. And it was dealing with a state constitutional right that does not apply here in Georgia. And so for all of these reasons and those contained in the filings and previous arguments by the state is asking the court to deny the motion for it.
May I have a brief rebuttal, Your Honor?
Briefly.
Yes.
I just want to correct points that have I believe are incorrect under the law. That at the time that Oklahoma and Roper were decided, also 0 other states had made any state statutes in regards to their decision about who and could be executed around the age that when we did 16 and 18. So that is not a prohibition for this determination. International norms are, of course, against this because the majority of the world does not engage in the death penalty. What I would note about Georgia's DJJ is that their actual purpose is to deal with youths up to the age of 21. But also, finally, I think it's really important for this court to understand that, you know, when Roper said 18 at that time, it was because they had to pick a number at that time. They had to pick something to make their
But Mr.
end.
Long's over 18, so
He is over 18.
what would you say about that?
What I would say about that is that the court didn't make any ruling about post-18 other than we're setting the line at 18. And do these things exist beyond that? And could people make arguments beyond that? They acknowledged that the science was still developing in those areas. What they said at the time was where there was 100% consistency, essentially, across the neuropsychological field. And they were able to point to that. And the reason why it's appropriate now, 18 years later, is because we are 100% consistency that the development exists to the mid-20s and that we are scientifically able to prove that it exists until 23. And
Would you agree that Massachusetts has certain state rights that Georgia doesn't have? So why should I go that far?
because Georgia, both Georgia and the federal rules have an evolving standards of decency standard, which is in the Georgia Constitution and it is in the federal Constitution. The Commonwealth in Massachusetts has their own statute for that. And so there are determinations that can be made under the state statute and the protections that one has. Like, for example, Georgia has a greater protection for people that are incarcerated in regards to their rights of incarceration. I've litigated that in solitary confinement issues. That's actually covered under Georgia's Constitution, but not under federal. So there are greater protections. But the same as the Gregory case out of Washington State, that was decided under Washington State constitutional rules. The difference between making a decision under the Constitution and the state Constitution versus the federal Constitution is that can't be appealed to a higher court in regards to that because it's a state constitutional determination. This falls under both state and federal. And the final thing I want to really correct is that the Sarnav case, the court did not reject the claim. The court found it was not procedurally preserved properly. And what the court in fact said is they said a court needs to look at this issue, that the claim is real. And that courts needed to look at it. The Sarnav case specifically said that. So I want to make sure that it's clear that issues of preservation affect a lot of these. But the court specifically said, and I'm quoting from the Sarnav case, which is 968 Fed 3rd 24, it's 2020. That the change that he proposes is certainly worth the careful consideration. That's not a finding of the court rejecting it, but they also did have to say that it was they failed to properly preserve it. They didn't raise the issue below, so they had to review it for a plain error ruling, which is different than what we're asking, which is a finding based upon the actual information.
I understand that. I understand why you're raising it now, so I don't have any issue with that. So
I think the challenge here, judges, is that you have uncontested science. And that science is exactly in line with the science that they had in Roper. In Roper, they had consensus in the science. And frankly, in Roper, they had to pick a number. And that's what the court even said. We got to pick a number. And they picked a number. So it is more, it wasn't flat arbitrary, but it was decided upon consistency of the scientists. And in 18 years, you can't say that the science hasn't evolved, because it has. And, for the state to say that we have to go on the science that they had at Roper just goes against Hall. Hall versus Florida very clearly says the court's obligation is to see where the science is now and to make our determinations based upon where the medical and scientific community is leading us. The judges in this, when they were deciding Hall, wrote their opinion in a way, I think, to delineate what we have to do as what you have to do as judges, and what you use in order to make those determinations.
Okay.
The only other thing I would say is that if the court is inclined to deny this, we are going to ask that the court certify this issue for review.
Your Honor, on that last point, the state would simply ask that that be at the time of interim review rather than...
I'm sorry, you asked it the what?
She indicated that they would be asking for the authority to appeal that decision to the higher court. I would ask that if the court denies the motion, that go to interim review, which would occur after we have the motions we've already scheduled.
I understand that the Supreme Court could go ahead and consider that as part of the motions that they're going to review. Okay, all right. Tell you what, give me 10 minutes and see where we are at that point in time. Okay. All right, we're going to be recessed 10 minutes. The court's had a chance to ponder a couple of different things in regards to defense's motion 28 and 28 Bravo. While I understand the defense's and appreciate the defense's argument as to the developing nature of the brain and how it and different things that affect its development in this particular case, and then that particular evidence has been presented for the court's consideration. I'm still going to find Georgia's constitutional Georgia's scheme at this point in time constitutional, and I'm going to deny the motions at this point in time. So, Mr. Anderson, if you will prepare a suitable order in regards to defenses 28 and 28 Bravo. In terms of a certificate of immediate review, Ms. Bell, I will deny that at this point. If it is appealable, or I should say reviewable, when the court sends after the motions have been heard for the unified appeal procedure, if it's appropriate for you to attach it as part of those particular motions that the Supreme Court reviews, you're certainly welcome to do so. But I'll let it, I'm not going to give a separate certificate at this point in time.
Thank you, Your Honor. I actually was only asking for it to be certified when it goes up for interim review. The court will send its own report up, and we're just asking that it be included in that. It's actually statutorily prohibited so far any longer for you to do immediate reviews. We wish that you could, but unfortunately it's statutorily prohibited. So yes, we are just asking that the court include it with interim review.
Okay.
Thank you.
All right. State anything further?
No.
Okay. When can I expect to get the orders for motions 7 through 18, 21 through 24, and 28 and 28 Bravo by parties? Go ahead.
Your Honor, we have...
There are also some other proposed orders. We have communicated with Ms. Weaver in regards to getting the transcripts so that we can get specifically the language that Your Honor asked for in these orders, and she's going to provide us the transcripts for these hearings so that we could get those proposed orders to Your Honor.
Do you believe that you can have all the orders presented to the court by April the 15th?
Yes, we can.
All right. Ms. Weaver, does that give you enough time? Okay. Mr. Anderson, what about you? Does that give you enough time?
Yes, Your Honor. And I would just like to acknowledge that I have 2 more weeks, but I will try and get it in earlier for the last hearing that we have.
All right. Okay. All right. So that... Okay, so turning to the states, motions to admit defendant statements and intrinsic evidence. I have you all booked for Monday, May the 20th, starting at 9:30, going the balance of the day. Is that correct?
Yes, Your Honor.
Do you believe that? Do you believe that to be enough time for you? To handle the state's motions?
Yes, Your Honor.
Yes, Your Honor.
Yes. No. Maybe.
I looked to the evidence out of his head, so yes.
Okay.
We don't foresee a problem.
Okay, I just wanted to know, just because I have some other matters I have to attend to, in addition to my role as a chief. Okay, so that's fine. We'll take it as it comes in that respect. The other thing I was going to ask you all: are there any other motions that I have failed to hear that you all have filed that would at least get us through the period of the Unified Appeal Procedure Phase 1.
Your Honor, I do not believe that there are any beyond what the court has already addressed and ones that we know that we will be addressing later. However, once case management comes up, I represent to the court that I will go through the filings to see if there's any additional motions that have not been addressed.
Okay. And we can certainly do that after the 20th of May. Ms. Bell, madam, anything?
No.
Mr. Lamar?
No, yeah.
Do you all anticipate filing any additional I mean,
Yes.
I'm not gonna hold you to it. I mean, if you do, you do. If you don't, you don't. Fine, but
At least, yes, Your Honor. I think a lot of, we do have motions regarding specifically more particularized motions. I mean, this generally addressed the discovery motions that we have, but we have more particularized motions that we are working on to get before Your Honor, and those will deal with specifics of the evidence that we've received so far.
okay, when do you anticipate filing those motions?
I would, if the court is amenable to it, I'd like to do it after we have the hearings, because there will be additional motions coming out of those hearings, I think, as well. And so, and because I have a trial coming up and Mr. Lamar has a trial coming up, if the court will be amenable to us getting them to you by the end of June.
State?
For particularized motions, no objection to that timeline.
All right. Let's talk about them on the 20th of May, okay?
Yes, Your Honor.
And I'm going to direct it, if you should be able to tell me, or should have filed them by that time. So I can, because here's the challenge, Ms. Bell. I got to be able to schedule them. And I just can't kind of have them just kind of dripping in, because I do need to put, you know, the UAP requires me to kind of at least just hear the motions and then do the report. So I need to finish the particular motion. So I can't be kind of like, well, we got two other motions I want to hear. Well, I'll hear them, but we need to kind of base upon what you have. And I don't believe does the state got any additional discovery that they're filing at this point in time, or is there anything else you're aware of?
If we get more discovery, we'll turn it over, but we've given over everything.
Yeah, so I mean, you should have the universe of stuff that you are going to file, the bulk of your motions. I'm not going to hold you to if something else comes up.
Right.
I'll do that for good cause, of course, as you all know that. But I'd like to at least kind of work toward putting a pin in the motion so I can do the report.
Agreed, and that's why I asked for the time, because I was hoping that we could get like just the whole.
Well, hope's not a strategy. You know, I'm famous for that. Okay.
I'm sorry?
I spent 35 years in the military. Hope is never a strategy.
Hope is never a
We
strategy.
we plan everything that we do so that we can finish or be successful on a campaign or whatever it is. So that's why I say hope's not a strategy. Okay. So
Agreed.
give me a date that you think that you will be able to reach for, given what we have, or given what you have right now. And I know some other data points. You just told me that both you and Mr. Lamar both have other obligations. So given that, I want to make sure that you have enough time to do so. So do you think that you would be able to file said motions at least by the 20th of May so that I can schedule them? Because of course it will take time to schedule them. I figure that they won't be probably on the court's docket till sometime in June or early July, or June or July or August. So do you think that that would be reasonable based upon what you know so far?
I don't think that I can, and I don't want to mislead this court. I have, I've spent the last year trying to manage about 12 death penalty cases because we're down first chairs in our office.
Sure.
And so I have learned what my capacity is.
All right.
And in light of the fact that I have a death penalty trial set for myself for September and a non-death penalty trial already, both of these are specially set in May, and Mr. Lamar has a death penalty trial set in March, I think that we could get them to the court by the end of June before I get dragged into solely focusing on my death penalty case that is going to be starting trial in September.
So you believe you could file it, you believe that you'll have your, other motions filed by the 30th of June? Is that what you're telling me?
Yes, Your Honor.
Okay. Let's aim for that date.
Yes.
Okay, let's aim for that date. And what I'll do is we'll take a little stock in May, and let me know how you're doing. And if you tell me, Judge, I think I'm going to be able to meet the end of June, then what I'll just do is I'll status you sometime thereafter to set those dates, or sometime after your September trial. How long is that supposed to go? Any idea?
Unfortunately, the way it's set right now, the court, it's set for September 24th. The court just indicated they may have to make an adjustment because of Cobb's Fall break, and but she told us to keep clear until Thanksgiving.
All right, okay. I'll do the best we can, you know, so. State, anything further? Or anything in response?
Nothing further from the state. We agree that a date should be shot for. That's not the most articulate way of saying it.
Or goal. It's a goal. It's a goal. It's a goal. But we should plan for at least, so I'm going to put in my notes that I'm going to inquire on the 20th, and that sometime in early July, what I'll do is, based upon what has been filed, and we can set a date to whatever date or dates. Okay?
Yes, Your Honor.
All right.
Maybe the excuse.
Yes. Do you have any other business before me, councils? All right. Then, given those directives, we'll be in recess, and we'll see you all then, okay? All right. Thank you very much, councils. Appreciate you.